We're still looking for Sergei Kozakov. Can we invite him? Esteemed participants of the forum, so today we are finishing the day one, and the discussion that we're expecting is devoted to such a thing as judicial reform and its impact over development and protection of the competition, which is a direct continuation of the OECD recommendations. I think that the discussion where we expect participation of our panelists is expected to be quite hot and interesting. Based on the results of this discussion, we'd like to develop some recommendations to our government concerning the judicial reform. We can see here Mr. Andrij, head of Committee for Competition Policy and Legislation, OECD. We also have here Pierre Rauch, the president of the Agency for Competition of Luxembourg, Mr. Bendisuk, the head of High Council of Justice, Bogdan Lvov, the president of High Commercial Court of Ukraine, Mr. Kozakov, head of High Qualification Commission of Judges, and Mr. Sayenko, who is a partner to law firm Sayenko Kharenko, and also he is the chairperson of the Public Council. So what actually is the set of problems? So what's the set of problems that we intend to discuss? We see that the law on protection of economic competition, you remember, it was adopted in 2001, provides that any disputes related to decisions of AMC shall be subject to consideration by commercial courts. Commercial are within jurisdiction of commercial courts, and the whole system of views concerning the right jurisdiction for this kind of dispute had been discussed, and actually for a long time, and this law just depicted the current situation at that time. Later on, we had the system of administrative courts, and speaking directly, there was kind of a fight between these branches of judiciary concerning the right jurisdiction. Business entity could actually choose the court which would be competent to resolve a dispute. The result was that instead of legal certainty, we are using the principle of legal uncertainty in Ukraine with respect to this issue. Further on, the situation evolved in such a way that a number of laws were adopted and created kind of dual approaches existing until today. First of all, I mean the law on administrative justice provided that the jurisdiction of administrative court would apply to all public legal disputes except for the disputes where the law provides for a different type of judicial impugnation. So actually that provision means that the competent courts would be commercial court. The law on commercial courts really introduced many novelties in the practice concerning the disputes on competition, and I'm really happy to see here the representatives of judiciary who participated in resolution of hundreds of these kind of disputes. Also, we have here judges who started this titanic work on determination of the proper jurisdiction. I can name you probably dozens of commercial judges who took part in the resolution of such disputes. What happened later in the area of development of the legislation? After that, later on, I cannot just turn the page by some reasons. Let me remind you that then the law on public procurement was adopted, by which the disputes in this area would be resolved by administrative courts. Then we had the law on governmental assistance to business entities. It will take effect this August, and again, according to that law, these disputes will be resolved by administrative courts. And finally, it's time for judicial reform. So the legislation concerning judicial reform directly provided for establishment of a separate court for intellectual property disputes. Of course, this law is not now pinpointed with the specific procedures, but actually that may be also the right jurisdiction for the competition-related disputes, because unfair competition actually is about violation of existing rules. There is an idea to establish with Supreme Court of a chamber responsible for resolution of the disputes, as they called it, competitive or anti-monopoly disputes. So as you can see, the legislators are following the kind of a dual path, although the very core of this dispute cannot exist without the cornerstone of definition of the market. That applies to all kinds of disputes related to the competition, where now the courts are competent to judge, but the initial decision is made by the AMC. That may lead to kind of a dualism, and the case law, final case law, may be finalized maybe in several years, when these disputes will reach the respective chamber of the Supreme Court. I apologize for this long introduction, but I'd like first to briefly inform our foreign guests about the background. So what are suggestions about the right way for Ukraine to take in view of very variable experience existing in other jurisdictions, where these disputes are with the jurisdiction of commercial courts? In some other countries, administrative courts are competent to hear such cases because, again, they certainly include the public element. Of course, the final decision will be made by Ukraine, but I'm happy to see here three high-level officials: Igor Bendesyuk, Bogdan Lviv, Serhiy Kozakov, who will certainly be taking direct part in decision-making with this respect. I apologize, but first of all, I'd like to hear from Frederic Geny, because the recommendations provided by OECD includes several direct statements concerning specialization of the courts, concerning the certainty in this area. Please, Mr. Genis, the floor is yours.
Thank you. Let me get rid of this. Thank you very much. Let me go directly to the question you asked. I mean, from what I understood from your presentation was that there has been, first of all, a lot of changes, and there is a question about whether it should be an administrative court or a civil court or commercial court that should be dealing with a competition issue. And the point I want to make is that I think it is less important to know whether it's an administrative court or a commercial court, but more important that it be a specialized court. And I'm going to try to explain why. And my first example of this is a quote from a British judge on the competition issues, which says, and British judges are usually very well trained, basically expressing the idea that he does not understand anything about the competition issues and the economic issues which are underlying this, that he's going to sit there and look at this case, but he just does not understand what it's all about. And this reveals a real problem of understanding between the economists and the judges, which is specific to competition law, because competition law is the only law which is based on an economic theory, and where the meaning of competition or the meaning of anti-competitive practice cannot be found in the law. It's usually not spelled out, but has to be found in a reasoning, which is the economic reasoning. So that creates a particular challenge for the review of decisions of competition authorities. I happen to be an economist, but I served for 8 years as a judge on the French Supreme Court. So I also have an experience as a judge. And I became quite aware when I switched or moved from being an economist to being a judge of the differences of approach between the two. I'm quite familiar with what's in the mind of an economist, and I can show it to you. Now, that's what's in the mind of an economist. And by the way, this was drawn by a female economist, so it's not a sexist comment. But the point there is that the economist has a very particular way to think about issues. The economist starts from the theory, then the economist looks at the reality, sees that the reality is not like the theory, and tries to make the reality like the theory. That's the basic idea. We have a theory of competition. We see that there are anti-competitive practices, and so we try to make competition more effective. This is not the way the judges think. They never start from a theory. They start from legal principles. Then they go to the facts, and they see if the facts are match the legal principles. So that means that in the dialogue between the economist and the judge, you have very different standpoints, which are sometimes leads to mis or lack of comprehension between the two. The judge is not so interested about, the economist is always interested, what's the goal of the law, okay? Because I will interpret the law according to its goals. The judge is much more interested by what the law says, and I will stick to what the law says. The economist looks at the relevant facts. In other words, he separates what is not relevant for the economic analysis to know whether there is a violation of competition law, and the judge doesn't do that, looks at the facts in general, what happened, and see how he can apply the legal principle. The economist will apply a theory of harm. He will construct a story saying, if I have this very concentrated sector and all the firms increase their price at the same time, and they met, I don't know what they said, but they met the day before, and they increased their price simultaneously, it must be that they agreed on something, and therefore that I have a violation of the law. That's a theory of harm. a reconstruction of the reality. The judges don't like to do that. They like to have direct evidence on the issues. We have differences between correlation and causality, between deterrence and proportionality. The economist wants to make sure that the competition law deters people from engaging into anti-competitive practices. So they want to put large sanctions just to deter people from doing it. The judges are much more sensitive to the proportionality between the violation and the punishment. And therefore they are a bit worried when the economies come or the competition authority come with very large sanctions. And on like this. So we have two different perspectives. Okay. It's quite useful to know that, because the second point that I want to make is to interpret competition law, to apply competition law, to enforce it. The competition authority has to go back to economic reasoning in three directions. One of them, concepts. What is competition? What is consumer surplus? What is efficiency? All this is, in economic theory textbooks. Okay, so concepts. Second, methodology. How do I establish that there has been an anti-competitive harm because of this practice? Maybe in cartel we don't need a very complicated story, but when it comes to abuse of dominance, we need to have a theory of harm, and therefore we have to rely on economic reasoning. And the third dimension is measurement. How much damage was made by this cartel or by this abuse of dominance, okay? For this, I have to have some notion of what the demand was like, what was the elasticity, okay? So there are three levels: concepts, reasoning, and measurement, where the judge or the competition authority has to rely on economic approach to be able to enforce the law. Now, the judges typically know nothing about economic theory. That's one. And B, the judges, everybody wants to educate them. If you're a structural engineer and there's an issue about a building that fell somewhere and you may be liable for damages, you want the judge to learn structural engineering so he will understand that it's not your fault if the building went down. Medical doctors want to teach medicine to judges. Economists want to teach economics to judges. Everybody wants to educate them. So there's no way, practically, it can be done. Okay. So, how do we solve the problem? Well, the problem is to try to get judges to understand the subject matter of competition. There are three types of ways. The first one is an institutional tool, and this is the specialized court. Why is a specialized court superior from that point of view? Not so much because the judges are necessarily better at economics, but because they see competition cases all the time. They have an incentive to invest in understanding those cases, and they also acquire experience. Now, in some countries, you cannot have a specialized court, because that's also a dangerous path, okay? You start with a specialized court for competition, and the IP people say, oh, well, we want to have our specialized court as well. And then you keep on going, and you end up with a lot of specialized court, a labor court, et cetera, et cetera. Okay, so maybe it undermines the unicity of the legal system. So in countries where you cannot have a specialized court, the next best is to have a concentration of cases on a few judges in a general jurisdiction. For example, in a commercial court, you have a chamber that will hear all the competition cases. Okay, so that's the institutional tool. There are procedural tools also that I'm not going to go into because I don't think that's the issue tonight, but procedural tools which are ways in which one can organize the dialogue between the competition authority and the judges and the experts in such a way that the judges will understand what is happening. And finally, there are methodological tools, which I will also skip because I think that we want to focus on the institutional tools. So the short answer is, if a judge, no matter how well-meaning he is, hears a competition case every 5 years, he's not going to spend a lot of time learning about competition. And therefore, there is going to be a difficulty for him to deal with a competition case. If we have an institutional setting where a small set of judges hear a lot of competition cases, they are better able to deal with the complexities of competition law. That was my message. Thank you.
Mr. Genie, thank you very much. I fully agree with your point of view. Indeed, the institutional approach is very important, and I think now we are in a decisive point because now Ukraine is between the two ways. I mean, we need to decide what kind of judiciary we want to establish, what would be their competencies, specialization, etc. It's very important position, and I'd like to hear the opinions of the President of High Council of Justice of Ukraine, Mr. Igor Benedisyuk. Well, under your permission, I would prefer to hear from the President of High Commercial Court because they are now competent to review such cases. Within our competence, we certainly will participate in these processes. Maybe I'll share some of my thoughts. So please, the President of High Commercial Court of Ukraine, thank you. Alexander Ivanovich, first of all, I'm very pleased to be invited here. And second, I need to note that I was pleased to hear that we have no discrepancies with the esteemed foreign experts with regard to specialization. And the specialization is not a privilege for judges, it's just a guarantee to enhance the quality of justice. Indeed, this specialization is now evolving all around the world, starting from specialization of judges within a court and up to establishment of specialized units. This is what the commercial courts did. They created special chambers for intellectual property, competition disputes, etc. And maybe the highest stage of development, such evolution, would be establishment of a specialized court. Well, fortunately or unfortunately, maybe Ukraine will not be able, at least now, to create specialized courts for in each area. But we have well-trained experts with participation of the IMC. For 10 years, our judges have been trained on different subject matters in the law. Our legislators, after establishment of administrative courts, actually created kind of uncertainty with regard to the jurisdiction which continued to exist. Until the year 2015, I mean, what is the right court to challenge a decision of AMC? I don't want to really, I will not try to dominate very openly, but since we deal with intellectual property, I think that the protection against unfair competition will remain within the competence of commercial courts. And every time we deal with effective protection of the rights of the business entities against anti-monopoly activities without participation of AMC, and we know that such direct judicial practices exist in Europe, well, and for that we only have certain obstacles. The obstacle is if the business entity files an action with the court with regard to abuse of dominating position. The court can only use the injunction, which is not very effective in our condition, while the Anti-Monopoly Committee has an opportunity to apply a penalty, which is much more effective tool. But that does not mean that such disputes cannot be heard without participation of AMC. So I think if we are dealing with the same nature of legal relations, we should not really fragment this relation among different competences. And I'm not trying to defend any corporate interests of commercial courts. It's just that the state needs to build a system which would be the most effective in defending certain rights within certain areas. So I hope that sometime in March, in connection with the establishment of the Supreme Court, Alexander Ivanovich already mentioned that according to the law on judicial system, that will be cassation level commercial court. So they will have kind of respective chambers for anti-monopoly disputes and intellectual property. So now soon the respective amendments will be made to the legislation on procedure. We expect for a new version of the Code on Commercial Procedure, Code on Civil Procedure, and Code of Administrative Procedure. So as we all understand now, the first priority is to clearly delimitate jurisdiction so that different jurisdictions cannot consider the cases of similar nature. So I do hope that we will be able to really delineate delimit the jurisdictions very soon. And the legislators will make decisions on establishment of not only anti-monopoly court but also a court on intellectual property, which certainly will be related to unfair competition. So maybe we will suggest to the legislators to vest the same court with the competence to hear cases related to competition legislation. Luckily, the number of these cases is not large. Well, had we had the real competition in Ukraine, the number of such cases would have been much larger. But in 2015, the courts just reviewed 737 cases of this nature, and 2016, 931. Much smaller number of similar cases were considered by administrative courts. So, as you can see, this is not a big number of cases, so that will not entail any major expenses of the government. In the meantime, that will allow for training better specialists and to consider cases within the good times.
Thank you. I'll also ask the participants to defer their questions until the end of the session. Mikhailovich, thank you. Let me support and express my concurrence with national and international experience. If we look at our experience of building specialized economic courts, it is important to preserve this specialization in the future. After all, it's not important how we preserve it. More important is to clearly define the jurisdictions. Well, the practice has already done that, and I hope that the lawmakers will do that in the amended procedural codes. At least we will certainly push for that. We need legal certainty with regard to the amenability of those cases. At the same time, I have a word of warning in the light of the ongoing reform. We should remember that by establishing a specialized, say, anti-monopoly or competition court, we can make the proceedings less convenient for the parties. Probably we should think of a mechanism of appeal in order to expedite proceedings, to appoint an intellectual property court, the appellate instance, and allowing economic courts that are based in each region to consider disputes arising from competition legislation. This is my personal opinion. It's important to exercise some caution, because otherwise we can end up with having a mechanism making the proceedings less convenient. In my judgment, it's the easiest way is to clearly define the procedural codes and appoint a court to hear such cases, and that said, this jurisprudence should be well consolidated, well adjusted, so to speak, at some single appeal instance, because first the jurisprudence is generated in the regions and then reviewed and consolidated by that appeal instance. So whereas specialization of competition judges raises no brow, I believe that we should just wait before the lawmakers pass amendments to the procedural codes. Institutional mechanism will certainly be effective. Now, how do we go about establishing courts like that? Again, Serhiy Yurevich may have better insight into that, merging the intellectual property disputes court might be of certain interest, especially if we decide to have one court acting both as first instance and appeals court. Thank you very much, and I'd be happy to respond to your questions. It's been a very interesting proposal. Serhiy Yurevich Kozakov, head of the High Qualification Commission of Judges of Ukraine, will now have the floor. Dear colleagues, I started the day today at 8 a.m. with a lecture on competition law of Ukraine and EU at one of the Kiev-based universities. In 1993, back in 1993, our esteemed colleague, probably the Ukraine's best specialist in competition law, Alexander Melnichenko, introduced me to the concept of competition law. It was called antitrust law, anti-monopoly law, and I had been specializing for many years in disputes like that before I was appointed head of the High Qualification Commission of Ukraine. In my intervention here, I could tell you more about the creation of this country's supreme legal authority. I mean, the new Supreme Court. Let me remind you that we now have the Supreme Court of Ukraine plus 3 specialized courts, high specialized courts. After the competitive selection is over, these 4 instances will exist no longer, and instead of a 4-tier system, we will have a 3-year system. The Supreme Court will have 4 cassation panels, so to speak: economic, administrative, civil matters, and criminal, and the Grand Chamber. Key to what's gonna happen then is not the court or its name, but its powers. And I hope that these powers will be specified, defined in adequate detail in the new procedural codes, apart from the law on the Supreme Court. And we hope that these new procedural codes, their drafts, will go public within several weeks, and then we have to be very, very careful about seeing that these ideas we are talking here about embedded in those codes. Well, the competitive selection, like I say, is going on. It's Ukraine's first ever competitive selection for the Supreme Court, because before that, the Supreme Court of the nation was created in 1921. No competitive selection. The procedure makes many current incumbent judges of the Supreme Court of Ukraine not very happy, but that's what the law says. The selection comprises tests, psychological testing, and the so-called judge's dossier or file. Representatives of 3 legal professions participate. Earlier on, there were only judges. Now we have judges, lawyers, and members of the academia specializing in law. The selection commission assesses them against such criteria as judicial ethics, integrity, and professionalism. Another novelty in the law, something that you won't probably see elsewhere in Europe or of the world. We have the so-called integrity or public council for integrity. By law, it is called upon to inform the Commission of any negative conclusions, findings, or evidence of lacking integrity. The new court to arise will have more powers, stronger powers than before, and I believe that the Supreme Court will actually generate some sort of a case law for lower courts, making the system much more predictable. In an ideal Ukrainian world, the parties bringing their dispute to first instance would be able to predict how the case can end up in the Supreme Court. Thank you. Pierre Rauch from Luxembourg will now have the floor. We are very much interested.
Thank you. Thank you. So, in fact, we have spoken about two problems, and in Luxembourg we are facing both of them. First, problem of specialization of the judges, but for a small country as ours, this is not only a problem in competition matters, but in other matters too. So all our cases go before the same court, but this court, or this tribunal, this judge is not a specialized judge. He copes also with different other matters. But all litigation on competition matters goes before this judge. The problem we are facing also, and you, Mr. Chair, explained about it, that is the length of the procedures. And that is another problem, and both problems, the specialization and to tackle the length of procedure calls for reform. But before we come to reform, we should look at the review of our decisions. Huh? So, and then I have to speak a bit of the structure of our competition authority and its place in the context of judicial review. So the Competition Council is not part of the judiciary. It is an administrative body. The decisions of the Council of Competition are then of administrative nature, and then it is subject to review before the administrative judges. There is a first instance before the administrative tribunal of first instance, and then there is a possibility to have an appeal before the administrative court of appeal. So I said the Competition Council is not part of the judiciary power. I would say judicial power, Mr. Jenny, and not judiciary authority. So it's not part of the judiciary in the domestic sense of this concept, but its decisions, notably heavy fines that can be imposed, are considered as being of penal, of criminal nature, and that means that Article 6 of the European Convention of Human Rights, this article speaks about fair process in due time. So this Article 6 of the European Convention of Human Rights is applicable to the procedures before the Competition Council. This means two things. First, the rights of defense that are laid down in Article 6 of the Convention must be, of course, fully respected. But also, Article 6, at least in the eyes of the Luxembourg legislature, the Luxembourg legislator, we had to install a separation, a division between the investigative phase of the procedure and the phase where the decisions are taken. So if a case comes before the council, the president has to appoint a counselor who is prosecuting, and this procedure ends up with a statement of objections. Then the investigation phase is closed, and this counselor can then not sit when it comes to the phase of making a decision. One can say this is a very strict application of Article 6 of the Convention, because other bodies, notably the European Commission, does not have this effective separation, division between, on the one hand, the investigation, and on the other hand, the decision of a litigation at the administrative phase. In Luxembourg, we are we are inspired by the Belgium and by the French law, who have authorities who have also this division between investigation, prosecuting, and on the other hand, decision. But contrary to the Belgian and the French system, it is fair to say that the decisions of the decision-making process in Luxembourg undergoes, in fact, 3 instances. If one considers the Competition Council, although it is an administrative body, as a so-called quasi-jurisdiction. This is an ambiguous, not a legal concept, but as Article 6 is applicable, it comes very close to a decision made by a judge. In domestic terms, it is not a judge, but as we apply the convention, Article 6, one can say we are practically speaking, we are a jurisdiction. So in France and in Belgium, the decisions of the competent competition authority may be directly challenged before only one court, which is the appeal court. In France, it is the Cour d'appel de Paris, and in Belgium, it is the Cour d'appel de Bruxelles. So there is no intermediary, as in Luxembourg, where we first have a tribunal of first instance that challenges our decisions, and afterwards a degree appeal before the administrative court. So we have then 3 degrees of instance the cases is undergoing. Now, I come now to judicial reform, because in Luxembourg there exist plans. They are not already laid down in a former statute, but this judicial reform might perhaps introduce a new degree of judicial review, and this is cassation. That is a kind of review that is not based on the review of the facts, but is only a review on the legal aspects of the decision. So you can imagine that if a cassation review will be foreseen, we will have a 4th degree of jurisdiction, and it is fair to say that the competition authority in Luxembourg looks this with some skepticism. So we are, if ever, this reform will take place, and we have a full-fledged administrative decision based on the procedures of Article 6 of the European Convention, and afterwards that might be attacked before the 2nd instance, the Tribunal of Administrative Matters, then to the High Court, and afterwards to the cassation. That might not be consistent with a final judicial decision made in reasonable times. And that is, of course, in a matter of competition, a very, very, very drawback. If ever this happens, then we, as a competition council, we would then strongly advocate for the introduction of settlement procedures, where, as the settlement procedures exist in EU law, and it exists in France and in Belgium and elsewhere. I speak about France and Belgium because our system is very much inspired from these 2 countries. And I think it would be for the benefit both for the authority but also for the enterprises to have settled their litigation in a reasonable time. And that is what we are calling for, so that our statement objection would not be challenged, our decision will not be challenged, but in turn, the enterprises could get a full or a large reduction of the fines. I think that would be the good parade to this long judicial review. So that is for the judicial review of the final decisions of the Competition Council. I see it is a bit late, but so I will not go too much into details. But this is not the only review. You can attack, you can challenge the final decision of the Competition Council. But during the inspection period phase, you can also challenge all kinds of procedural acts that had been done by the inspector, by the counselor who is in charge of the inspection. In principle, of course, all these acts should be challenged before together with a final decision before the administrative court. But there are some exceptions, and there are heavy exceptions. First is decisions for carrying out searches can be challenged immediately before the president of the tribunal. The president of the tribunal that is not actually competent in administrative matters, but the overall president of the Luxembourg Tribunal d'Arrondissement. And then even requests for informations might be challenged before the administrative judges. So it would, if I had some time left, but I don't have some time left, I could briefly illustrate these proceedings by an interesting pending case, but I think there is not enough time to do this. I'm glad to answer some questions from the audience afterwards.
Дякую. Thank you, merci, sir. The last in the row of panelists is Mr. Nahorny, and I would kindly ask him to be very brief. Well, I won't take longer than 40 minutes. It could have some very grim implications. Good evening, dear colleagues. I'll speak on how to make access to justice easier, and well, our foreign colleagues don't have the English version of my presentation and my handouts. Making access to justice, increasing transparency and efficiency of competition proceedings process. So the reform of the judiciary, we hope, will increase trust in the judiciary, radically increase trust in the judiciary, and we may well have a situation where anti-monopoly committee will be subject to demonopolization itself by providing access to individuals. We understand that priorities of individuals and government may be collinear or have different vectors altogether, which is fine. But what do we do about those whose rights are not adequately protected? Article 42 of the Constitution provides that the government promotes competition, and it means that we cannot but grant access of individuals to this type of proceedings. Private claims. In 1995, we were one of the first to start drawing up competition legislation, looking at US, Europe, and saw that the damage may be threefold of the claim. We then decided, after having conferred with the judges of the Supreme Court, to settle on the twofold amount. We thought that it did promote the development of the system of private claims. Why it didn't happen? Because there were other incoming factors that we didn't take then into account. Like I say, in proceedings in competition cases, it's extremely difficult to assess the damage. In EU, by the way, this methodology is in the making, and I hope that it'll soon be approved. With regard to rules of evidence and admissibility of it, in US, EU, and in Ukraine, competition authority is admitted as evidence, with at least one exception. If you have a decision made by a competent authority, competition authority in one nation, you cannot expect that it'll be admitted directly in another nation, but it'll be now statutes of limitations. Generally, it is 3 years. Say, I, as a consumer and another person who alleges damage done by unfair competition, can file a claim within 3 years, but the entire Monopoly Committee can initiate proceedings within 5 years after the date of violation. So you initiate a case 4 years after, but we, as private citizens, private individuals, cannot then claim damages. In US, it's 5 years, in EU 5 years, but at least no later than 1 year after the final decision. Another important right is to obtain discovery and disclosure. In the EU, there are special regulations in place. Well, here in Ukraine, we don't have relevant documents in effect. A couple of other important criteria supporting better access to justice.
An important principle for competition legislation, that's presumption of harm for potential buyers. What does that mean? If I am a monopoly and I sold at a monopoly price my merchandise to a distributor, and then the distributor sold it to the consumer, we presume that the consumer had damages and can directly actually appeal or file an action against me as a monopoly. In this way, we will not be there will be no need to involve, in the case, the distributor, who just would probably apply normal profit margin. Another important factor is the obligation to prove absence of harm. Harm or damages caused by perpetrator to the victim, provided that this perpetrator is a cartel. If the fact of cartel has been established, then the victim is not supposed to establish the amount of damages. The cartel member will have the duty to demonstrate the amount of damages. And the next point is the common liability, very interesting, good principle, where the cartel members, the victim the victim can sue any cartel member. The exception would be small and medium-sized enterprises and certain legal entities under specific programs. So many years passed after 1995, and we just realized that we did not generate the proper effect. We only now recognize that we need to give the opportunity to private persons to protect their rights on the basis of the competition legislation. And another important point is the collective system of protection and reinstatement of their rights. Of course, an individual or even small entrepreneur will never file an action with the court to compensate damages caused by a monopoly. So all around the world you'll find the system for collective protection. It's been the case in Great Britain since the 17th century, in the United States since 18th century. Unfortunately, in Ukraine we only have the institution of procedural co-participation, which is quite an isolated institution. There is a law, Article 25, on the rights of consumers, and according to that law, actually, the consumers may unite into association in order to protect their rights, but that has never been the case here. In European Union, this system was quickly developing in early 90s, and in 2013 there were recommendations concerning the general principles of the collective protection. What are the areas for application of this collective defense system? Many systems, including unfair competition, environmental protection, IP rights, many other areas. What's important here? Of course, this collective protection system should not create an excessive interest in use of this institution, meaning the abuse of this institution will need to be avoided. Like in EU countries, for instance, there is a special requirements for the plaintiffs, who can be the plaintiff in such a lawsuit, and there are specific features attributed to this person, like independent funding, legal entity, etc. All that can be done. This directive was supposed to be implemented by EU members by the 27th December 2016. Unfortunately, not all of the countries yet implemented that. Only 10 countries implemented it in full. Number of other countries are now at the final stage of implementation, and Cyprus, France, and Greece have not started yet this process. What does that mean? That this system has been operational for a number of years and will be happy to test this system. I am sure that we'll be able to find legal entity who would be interested to test the European system in this country. So, welcome to participate. And probably my last point, because of time, when adopting the criminal code in the new version, our committee had many discussions, and finally it was decided to remove from the criminal code Article 155C, which was devoted to fixed prices by conspiracy. At that point of time, AMC members were never involved into investigations of this kind. Well, the name of the article was Conspiracy on Fixed Prices, but after the judicial reform and increase of trust to this system, probably we will need to reconsider this approach, because as we can see, most of the cases with the Monopoly Committee are the cases about dominating position, I mean a monopoly, but of course the cartel members are very reluctant to disclose the whole information. They will hide evidence to make sure that AMC will never uncover their real activities. So this kind of investigations will remain being ineffective. Why other countries can do that effectively? As we can see on the right-hand side, it's about the United States. The perpetrators in cartel proceedings can be both physical, both natural and legal persons, and the number of the respondents in this number of accused under such proceedings is quite big. So all of them have a chance to do the plea bargaining. Thus, they may obtain immunity against further prosecution, and but they will have to disclose their respective information to the interests of the prosecution. So we need to reinstate the system of the liability. I'm talking just about administrative liability, not criminal liability, where probably AMC would be able to initiate proceedings, while the decisions could be challenged through the court on the basis of a fair trial. I will not talk about unfair competition now. I just will say that after the limitation of the powers, after this decision to separate powers of investigation and decision making, will face a serious challenge about this powers concerning specific model of separation of these powers. So this is the slide where I depicted the respective authorities that can make decisions within the committee, like Collegium, Anti-Monopoly Committee, territorial authorities, etc. And we certainly could create a system where any decisions made not by the committee but by these lower level authorities might be challenged only before to the Anti-Monopoly Committee, the central authority, and then you can actually appeal against decision of the Anti-Monopoly Committee with the courts. Well, territorial level decisions would be challenged or appealed to the Anti-Monopoly Committee. Well, certainly we could use also the system of common courts, But if we organize the specialized competition court, we need to centralize any decision-making process. Talking about inclusion of administrative court into the system, it's quite possible. The task of the administrative court would be then to reinstate the violated rights, and then the case would be remanded back to the committee, to the MC, because we cannot admit the situation when the committee has investigated a case, but with some violations, like for instance, they omitted some procedures, and then the full case will be dismissed. It's not admissible, first of all, because this is waste of funds, and but still the justice needs to be administered, and the court then will have to order the completion of the case, or remanding the case back to the initiator of the proceedings, which then would conduct the hearings, etc., etc. In this connection, just my last slide, I would ask you a question. What do we mean by competition code of procedure? What should it regulate? The process of competition for the bodies pertaining to the MC? Or is that a process for administrative courts? Or is this a process for competition court? Or is that a procedure for the competition court? So that's still an open issue. It only needs further discussion with participation of the expertise of judges, because as we feel, we certainly need the code of this kind. Thank you for your attention. Thank you, Alexander, for this brilliant presentation. We're about to finish, but in spite of this late time, and in spite of huge volume of work that we've performed, we still have to ask a question, at least to give opportunity to ask questions. Do you have any questions or not? I can see, yes, Pavlo Lishuk, please, the floor is yours. We cannot hear without microphone. Good night once again. I'm from DF Group. First of all, I'd like to thank esteemed representatives of the High Commercial Court for building this case law related to anti-monopoly legislation. Thus, you actually develop the practices of application of competition law. This case law is very important because in our relations with the MC we always need backup plan. So what we found out is that now the High Commercial Court has two different legal opinions concerning the bid rigging. The first position is that first point opinion is that if the MC finds similarity between the bidding documents, that's sufficient evidence, but others say that we need to prove the nexus between the similarity of the documents and distortion of the results of the bid. Could you please then comment on how you would actually examine the evidence in these kinds of cases? Who are you asking this question to? Representatives of High Commercial Court, thank you. Well, thank you. What can I say? I hope it's still not the dual approach to the same issue. It's rather what I would call individualization and implementation of the principle of competitiveness. So if we are talking about distortion of the bid results, actually we believe that the very fact of preliminary conspiracy is the evidence of distortion and doesn't need any further proofs. Even if the bid was finalized with the market price, but the absence of competition still prevented the bidding board, bidding authority to decrease the price, because this conspiracy already distorts the very essence of the bidding process. Another part of your question was concerning similarity between the bidding documents as a proof, as evidence of the conspiracy. In this case, we have an individual approach. If a party can explain this coincidence or similarity just because the bidding authority distributed the sample forms to all the bidders, of course, we wouldn't be able to bring charges of conspiracy if they cannot explain the similarity. These are general principles of proof and the principle of adversariality with the courts. I mean, if there are a lot of similarities, plus there are some evidence concerning relations between the parties, then we can deem the conspiracy proven. Thank you. Please, any more? Yes, Gennady Pampucha, please, the floor is yours. Good evening. I'm from Belgium Arbitration Chamber. My question is to colleague Rauch from Luxembourg. It's concerning the international arbitration practices where the arbiter, and I represent this arbitration, where we had your compatriot from Luxembourg, the professor of Luxembourg University, Peter Kinch. And in arbitration dispute under his review, there was the amount of more than 1 billion. They achieved ideal situation between the Bulgarian and Cyprus entities, where they came to reconciliation agreements. In Ukraine, we are just talking about establishment of separate chamber concerning intellectual property and concerning the competition legislation. Maybe that will be the same court. My question for you is, do you believe that the disputes of this kind could be considered by international arbitration, if this is the dispute between parties coming from different countries? My question is to the legal firm, Sayenko. Do you think that the state would have the exclusive authority to establish this kind of court? We had an attempt here to create so-called tertiary courts in Ukraine, which would not be the state courts, but these are commercial relations. We are not talking about closed case. Like in Belgium, we have a certain category of cases which is not subject to arbitration. There are labor disputes, bankruptcy matters. So I have these two questions. So first, could the disputes of this kind be reviewed by arbitration? So, well, first of all, the floor is yours, Mr. Rouse.
I think competition litigation is, in philosophically speaking, is a public law. So, but perhaps you are referring to damage claims. So the private enforcement of damages. The problem is probably you have collective redress often, but not only. But if you have collective redress, then you have harm to consumers, and that probably does not fit to the procedures you are coping with. But once the victims of an anti-competitive violation of competition legislation are companies, why not bring it before arbitration? Frankly speaking, I'm not at all acquainted with arbitration legislation, but that would be, from my point of view, a first response. And greetings to my colleague, Maître Patrick Kinch, who sometimes is going to represent the Competition Council before these numerous degrees of jurisdiction in Luxembourg. Thank you.
Well, I'm confident that such system may exist. I'll tell you why. Because if the parties had the respective provision in their contract, let's say our electricity consumers or utility consumers concluded a contract with this monopoly which provides for the possibility to examine it by arbitration, then it's okay. But if such provision is not in the contract, that's a different question. But I told you about this potential system of collective claims. There are two different systems. One category is to actually suppress the violation, and the other one is about compensation of damages. Thank you. I think we can actually conclude our day one. I'm very thankful for your participation in the discussion. Pierre Rouse, Frederica Genie, and our high-level officials, heads of our judiciary. I also want to thank them for participation, for interesting proposals, and for this space of discussions where we can clearly conclude that we are fully supportive to OECD position concerning this specialization in general. But what kind of specialization we will have, what the legislators will decide with this regard, that's an issue which will be decided probably within weeks or months. I think the points presented by participants of our discussions are very important and need to be implemented through the law. So before concluding this session, I'd like to make some administrative remarks. Tomorrow, as you remember, we'll continue our forum, but it will start not at 9 o'clock with the presentation of Anti-Monopoly Committee, but at 10 o'clock. with a presentation concerning public assistance to business entities, because, as Mr. Trentiev said, the issue of the report of Anti-Monopoly Committee will be examined on 14th March this year. That will be at 3 p.m. at the open meeting of the Anti-Monopoly Committee, where they will present their report. Thank you all for your attention. Best of luck.